Welcome back to The Narrative. I'm your storyteller, Callistra Farah. 1 year on since the Madia High School dorm fire in Guyana, which claimed 20 lives, 19 teenagers and a young boy, the matter is still before the court, still in the stage of preliminary inquiry before a criminal court in Guyana. The lawyer for the teenager who was charged on 20 counts of murder is joining me on the program now, Dexter Todd, to speak about developments. We have not been hearing a lot about what is happening in the case, but there apparently have been some developments, including the state, Guyana, appointing a special prosecutor in the matter. Welcome to the program, Attorney Todd.
Thank you so much for having me.
It's been a while since we've had you on. So far, your client, she is now 16. She's had a birthday, still in detention. Any new developments in the case at this point? Still in the preliminary inquiry stage?
Yes, we are still in the stage of the preliminary inquiry. I can say that after 1 year, there has been quite some struggle with the prosecution in delivering this case. Out of the over 70 something statements that were tendered and were disclosed, so we're doing what is called paper committal. So paper committal is a process where the prosecution is allowed to tender the statements. So we're not taking the vis voce evidence of every witness. So they tender the statements, and then we supply a list, which we did. We supplied a list of witnesses that we are interested in cross-examining. And so that in itself, it has helped to move the case in a manner that is quite speedily. So we have had that happening. The state, of course, they have been meeting a number of challenges. The prosecution has not been able to answer a lot of the questions that we brought to the court based on what was before us. Remember,
Questions such as, because I know that
questions
back in
such
August
as
you did write to the prosecutor asking that the case be thrown out.
Mhm.
You were saying that there is
we
insufficient evidence to support murder.
yes, yes, we had maintained right throughout this preliminary inquiry that the charge against this young girl was very premature and that it required a proper and a thorough investigation, which we hold the view respectfully that was not done. So, in the preliminary inquiry now, where we have the witnesses coming before the court, we are asking a number of questions, and the witnesses are unable to answer the questions because of the fact that clearly they did not complete a proper investigation. For example, you have at least after 1 year, it is only now, which happened just 2 days ago, disclosures were allowed of the post-mortem report of 13 of the children. And because of course, remember, some of the young children died in a way in which they were not they were beyond recognition. So they could not present to say, well, okay, the post-mortem report was done on this body and identify the body. They then brought in a specialist from Barbados who did the examination and then sent the samples taken for DNA testing. Those results were not even back. So you have a situation where the witnesses are coming, but they could not give evidence to any particular deceased person. And so that in itself caused some trouble in the case. Then you move to the stage of the fire report. There is a fire report which is only based on the interviews done by a few of the children, but not based, but has no forensic element inside, which means There was absolutely no testing. A number of samples were taken from the fire scene and they were sent overseas for testing. Nothing came back, no reports. So, really and truly, even the police investigators could not even give evidence as to what started the fire, the accelerants which were used to ignite the fire. Nothing at all they could speak to. So so the state decided that listen, this challenge is a little too great. So they decided that they are going to retain as special prosecutors, which they did in the matter. So at this stage now, the special prosecutors who have been on board of the matter for about a month and a half now, they are now making applications as the case is going on for there to be disclosures in relation to certain statements, which we, of course, oppose. The court allowed the final disclosure, which was done 2 days ago, and that would have been the statement from the pathologist, and of course, who also was responsible for the DNA testing, as well as the post-mortem report. Again, the court held the view that how could you have advised on the file and pursue a matter, but these very vital statements you did not even have in the file. That's the same argument we have made. All right. And we did say that we have a concern that as we raise issues and as we try to present a case on behalf of this young girl before the court, we do not want a situation where the prosecution is now filling the gap as they go along. And therefore, there must be a cutoff in relation to when the court will say, I will not allow you to make any further disclosure in this matter. Of course, our common law principle is like many of the other Commonwealth jurisdictions, which the power to allow disclosure after the disclosure date has passed, for the disclosures to be allowed, is really at the discretion of the court. And so we did ask the court to not exercise that discretion anymore because this matter must come to an end. Imagine where a disclosure is made 2 days, just 2 days ago, in relation to the death certificates and in relation to DNA testing results report and so forth. You could imagine that that will further delay the completion of the preliminary inquiry because we were almost down to the last 5 witnesses, and then this entire preliminary would have come to an end. So this is further delayed, and we have now given a new date, which is the 22nd of July, for the continuation and completion of this preliminary inquiry, which we hope that the court will be able to accommodate us on that date, and we bring an end to this.
In any way to starting the fire, that it was circumstantial, that she had borrowed a lighter and a bottle of perfume, and she had said she would set a fire? Or has the state been able to introduce any sort of evidence that they believe can prove that she actually did start the fire?
No. That is clearly not where this case is going to be heading. This case is entirely based on that bit of circumstantial evidence. There is no direct evidence that this young girl started that fire. And I know that the case is before the court, and I'm not permitted to go into the content of the evidence which the young children give at the court. But I'm at liberty to say that I am still wondering 1 year after, why is it that this young girl was charged with such a hideous crime when absolutely there is no clear evidence leading to that?
You seem to believe, when I spoke to you last year, that this rush to charge the young lady, even when there really was no evidence that had been presented, that we knew of anyhow, that it might have been some attempt by the state to sort of take the mud out of their eyes, because the state, there was an inquiry into this, and the report was given to President Finale, which seems to say that the state did make some errors just in the whole conduct and managing of the Madia dorms, and that this rush
Yeah.
to charge may have been a way of deflecting from the state's responsibility and culpability in this tragedy.
I am, as I said, I have publicly said that I am very surprised at the conclusion of the commission. I believe that the commissioners, I hold the view that they were very competent, but their conclusion leaves one to wonder what really was the purpose of the commission, because there is again not even one solid developed recommendation that there should have been a forensic element to this investigation. Now, they concluded that this fire was maliciously set by a person. But I mean, again, how can you base your conclusion on several persons, their speculations? Because no one saw her. Actually, all the evidence which is coming forward clearly puts this girl in the company of others who are alive and who have said that they didn't see her leave the room during the duration and period of time when this fire was initially started to be ignited.
So no
She was
so no
she,
evidence of opportunity has been presented so far.
no, not at all, not at all. What the investigation tried to develop is that this young girl had a motive. They're saying that she made certain utterances, and that she, because of some phone that was taken away from her, and that she, of course, would have had a motive to do the act. But I hold the view that the people who are doing the investigation, because it does seem as though and I'm saying doing the investigation because it seems to me as though they're still conducting an investigation. It doesn't seem to be a closed investigation, even though this girl is, because there are so many elements and parts of the investigation which is still left hanging, that it could not be a closed investigation we're looking at. So let's take their argument that they have done an investigation. So let's say that the people who have done an investigation must have recognized that in this type of offense, there requires two important elements, which is fundamental in criminal law. There must be the actus reus, which is the act. The person must be had committed the act, and then there must be the mens rea, which is the person's intention. Now you frame this entire investigation on the mens rea without the actus reus, because nothing is pointing to this girl's act. And that is what I'm saying. The police, if they're saying that they had this young girl under suspicion as being the suspect of this crime, then they had her at their disposal to do a number of things. Not even her clothing were taken for analysis. Not even her hands were swabbed for analysis. You see? So really and truly, I wanted to know at what stage they decided that they were going to investigate this girl. Because from the facts show that this young girl moved from the scene of the fire with the others to the hospital. They were transported to the hospital. And at no point in time she was allowed to go anywhere. So she was always in the control of the state. So at a point in time where you're asking the police, as we are doing in the matter, where we're asking them to make sensible, logical links between the young girl and the actual offense. They are unable to do that. Every witness was unable to put that girl so far, and we only have five more, and those five more is primarily formal witnesses.
And
But the main
and
witnesses,
who are the witnesses that you have questioned during the preliminary inquiry?
we questioned the police investigators, and we questioned the remaining young girls who were a part of that dormitory, and who did give the police various statements. And I can tell you, there's always it's always very, you have to be very careful when you write a statement for someone. And we and the state, I believe that the prosecution is seeing the danger in the police writing a statement, but then you can't get the witnesses to come back and say that, because that's not what they said in the initial stage. And they've had a number of those in this matter,
Attorney
that they're
Todd,
coming to stay. Have
Attorney
stayed
Todd,
there.
are you suggesting here that the police created statements and had witnesses put their signatures or put their mark to it?
I am saying whoever would have prepared the statements, they have to answer some questions after this matter. They will have to answer some questions after this matter, because the evidence which is before the court, all of the evidence is not really supporting some of the statements which were submitted in this matter.
But
Not supporting.
when you questioned the witnesses, that particular evidence, the testimony given by the witnesses, are you saying it also is not supported by the statements that are in the case file that were
We have found
under their name?
we have found a number of those. Yes, we have found a number of those witnesses. I mean, I don't want to name them and to go into the specific parts, but I can tell you it was very alarming, at both at the level of the court and of course of defense, what we are discovering in this matter.
And
Because clearly,
go ahead.
the girls who were in that dormitory did not come to say in the court that the young girl left that room. But from the statements, that's not what you're seeing there. You're seeing a lot of things, but you're not seeing what they. So when they're actually before the court and they're being cross-examined, they're giving their story, which sometimes I wonder, why is the state not stopping this case?
And do you have any motions that you plan to file, or are you simply going to go through the process of the preliminary inquiry and see what the magistrate decides, whether he kicks it up to the High Court or
Because
throws it out?
because we are so far in the process, I have been a little more comfortable with the position that we should allow the preliminary inquiry to conclude, because we are so far in the process. It's not more than one or two more hearings, and it will come to an end.
And has the magistrate agreed to close off the disclosure period? I know disclosure
Yes.
is up to his discretion, and the prosecution may come with a piece of evidence that is so strong that the magistrate feels compelled to allow it in. But has he given any sort of indication that, he has had enough as well? It's been a year, and you're saying that you're still presenting evidence that maybe should have been in 6 months ago, like DNA
Yes.
information and that sort of thing.
Yes, the magistrate has represented clearly that the court is not prepared to allow any further disclosure after this final disclosure, which was done 2 days ago. So when we go back to court on the 22nd of July, we are expected to continue the preliminary inquiry until its end. There is no other application which will be entertained by the prosecution to allow anything in, because the new special prosecutors are also in a situation where they are realizing that a number of things are not there that should have been there. And so they have to, while they have to present what is in the file, um, we cannot allow them to be now filling the gap as we go on in the case, or else we're never going to finish. We're going to have to start this case all over again, because I'm telling you, this matter was not properly investigated.
It's almost as they're not having two bites of the apple, they're eating the whole apple.
No, they will not under our watch and that of the court. This must come to an end.
And so far, your client remains in detention. It's been more than a year and a few days since she was taken into custody. What is she still in spirits? What is her, her state of mind, her demeanor right now? How is she coping with, a 16-year-old? She had a birthday behind bars. What's going on with her?
So it is difficult for her, and I think after every sitting, she becomes a lot more emotional about what's happening, and sometimes we have to spend a little more time in trying to make her understand when we are not able to go to have the family, her mother, bring it home to her that it's a process. She's quite young, and so understanding the dynamics of the court and how it works and so on sometimes is a challenge. But I can tell you it's difficult, and she really needs, and she's willing to go back home and to go back with her family, because it's been very, very amazing for her.
Has she been able to have periodic contact with her parents, her mother?
Yes, I am told that situation was improved, and so it's by of course notification. Once the advance notice is going, the visits are allowed.
And based on all that you have said, your client continues to maintain her innocence, that she did not set this
Yes,
fire.
yes, yes, yes. She has maintained that, and if if we as our defense lawyers, if we had any doubt in the case, I'm telling you, as we go witness by witness, we are seeing that this girl is really, really telling the truth. She did not set fire to that building.
All right. Attorney Todd, I want to thank you so much for joining me on the narrative for this update. Hopefully, we can speak to you on the after the next sitting of the preliminary hearing into this matter, just to get an update on how things are going. Thank you for joining us. Appreciate you as usual.
Thank you so much for having me, and thank you so much to your listeners.
Right. This is The Narrative. I'm your storyteller, Callistra Farrier, speaking there with Dexter Todd, who is representing the 16-year-old teenager in Guyana who's been charged with 20 counts of murder after the Madia fire 1 year ago at the secondary school dorm fire in the town of Madia, which claimed 20 lives, including a young boy who was the son of the dormitory mother in that place. The victims were unable to get out because the building had bars on it. They claimed that it was to keep the students in because there were issues of sexual exploitation, and the girls were running away and getting involved in things that they ought not to be involved in. And so reports that the dorm mother could not find the keys in time to open the door to allow the children out, and the Guyana government ordering an investigation into this matter, the results of which have been presented to President Finale, and some areas of weakness identified, but no conclusive blame being laid at the feet of the state of Guyana in the handling of how these young ladies, how these students were allowed to live in the Madia Secondary School dorm. More when we come back.